coming this afternoon. I'm Ian Angus. I'm one of the people appearing on the head note of a lawsuit that was served on this municipality 2 days ago, and along with others that have been involved with this whole situation for some time, we're here to explain what it is that we've done and why. First, I'd like to have you meet Bill Bickle, who's there on my left, who's been instrumental with Rick Norman down at the back and myself. Our claim to fame for the past 2 years as being involved with area rating, and that has led us to an investigation of the low-level waste host fees that we're here to talk about this afternoon. I also, I got 2 other thank yous. I don't know which order, but I'll take a shot at it. First of all, thank you all of those from the media that are here to be informed by us. Please feel free to ask any question whatsoever you want. If you don't want to answer it, we'll blame it on Bill. Also, I'd like to thank all those who are candidates for election this next month, because it's going to be you that are going to have to deal with this situation. This is not a standalone thing, but this is, because of the way we have proceeded, something that has to be dealt with by the town before January the 22nd, 2015. Let me begin by explaining to you what this is. There are several forms of lawsuits. One is the kind that you start with a statement of claim, and you have plaintiffs and defendants and wait a few years and then go to a very expensive trial, and there are witnesses and all the rest of that stuff. There are originating motions which are to deal with a specific issue that doesn't need a full form of trial, and one of those ways of proceeding is by way of what they call application. Our legal proceeding is an application. It is an application to a judge of the Superior Court to determine an issue. Actually, 3 issues. First issue is there a trust? The $10 million hosting fee that the Township of Hope was awarded by the federal government was, we think, subject to a trust, and I'll explain why. The second question is, if there was a trust, is the trust still continuing for the benefit of the beneficiaries? Because if you've got a trust, you have to have beneficiaries. Someone has to have the ultimate ownership of whatever it is that the trust contains. The third question we're asking is for an accounting. Since 2001, when the money was paid over by federal government, it has been used for a variety of things, including, by the way, the thing that it ought to have been paid for, but unfortunately that usage has been sort of for a fractionally small amount of the money. So let me start with a history of this. Back in the mid 1990s, Hope Township, having looked at the siting task force effort of the federal government to locate a storage site for the low-level waste in this area, put together a committee called its Environmental Committee, Hope Township Environmental Committee. The person who was made president of that committee, Dean Ross, is here to my left. Through his efforts and the efforts of his committee, Rick Norman was on that committee, they came to the council of the then township and said, look, there may be a way that we can store the low-level radioactive waste locally here and everything will work out, as opposed to trying to ship it out of town and very expensively going nowhere with that type of project. They have persuaded council that this should be looked into, and over the next 2 years, the framework of an agreement was worked out. At that time, Hope Township was working with Clarington, because aside from the low-level waste storage site at Welcome, there is one at Port Granby, and that one was in trouble. It was leaching down right into the water and had to be dealt with. Then Port Hope realized what we were doing, and they joined the group. And so by the fall of the year 2000, we had a framework of an agreement. The agreement provided for how the federal government was going to proceed and how this storage facility would be designed, have to be approved by the CNSC, which is the governing commission for things nuclear, etc., etc. But it also included what they called a host fee. Each of the 3 municipalities involved was entitled to $10 million for their inconvenience, for their stepping up to the plate and accepting responsibility for the wastes, leaving them in their community. And it's the $10 million that the federal government made available to Hope Township that is the focus of this whole subject. Because Hope Township dealt with it differently than Clarington and Port Hope. Clarington and Port Hope took the $10 million, and it was subject to a condition, though, that if for whatever reason the wastes couldn't be stored in the community, and that was a possibility, if the storage facility couldn't be adequately designed, or if for whatever reason all the wastes were taken away out of their community to somewhere else, then that $10 million would have to go back to the federal government. If they weren't a host, they couldn't have the hosting fee. Fair enough. So the condition on Clarington's and Port Hope's $10 million was that each municipality was obliged to return the money if there wasn't going to be a licensed storage facility in their community. With Hope Township, it was different, because the money never went to Hope Township. There are several reasons for this, but basically the underlying reason is that Hope Township was well financed, it had no debt, and had been reducing its taxes every year for the past 9 years. It didn't need the money. So the terms set by Hope Township were that the municipality did not receive the money. The money was to go into trust for the ratepayers, and the interest from the money was to be utilized to reduce the municipal taxes that the ratepayers pay every year. That was how we figured that this money would most directly benefit the residents of Hope Township. Then along came amalgamation and all of that. New council, new municipality, and the first thing that Port Hope did was that they changed the trustee from Royal Bank or Canada Trust to their own bank, which is the CIBC. And then they started using the money without strict regard for the conditions imposed on the Hope Township money. In other words, if you considered that Hope Township's terms were Schedule 8 to the agreement, which they are, and the page before had the conditions on Port Hope's $10 million, that's Schedule 7. Port Hope acted as if all the money was Schedule 7 money. They sort of didn't bother to notice the stricter terms imposed on the trustee in the case of Hope Township. This, as I said earlier, yes, they used some of the money to lower the taxes. Give credit for that. They also did things like buying fire trucks and put a lot of the money into their reserve called the Building and Equipment Reserve. And the vast majority of the interest money, which belongs to the ratepayers, has ended up in the Building and Equipment Reserve of the Municipality of Port Hope. It is here that I have to mention that not one building has been erected in Ward 2 since amalgamation. When the CNSC actually licensed the storage facility at Welcome, and this is going forward to 2012. The condition on Port Hope's $10 million was deemed to be fulfilled, and so Port Hope, Schedule 7 page, figured, okay, we can do what we want with this money. The next page, Schedule 8, they figured they could do the same thing, but they forgot to read. Because it doesn't matter whether or not the CNSC has issued a license. The use of the money must remain as set out in Schedule 8 of the agreement. And you can't just change a trust because you want to. There's a process to do that. It involves going to court. It involves following certain set processes that air the subject and allow the court the opportunity of deciding, in the absence of anybody else, if the change to a trust is appropriate or not. That hasn't happened, as I mentioned. Also in 2012, the municipality struck an area rating working group to try to figure out how to equitably apportion the municipal taxes between the urban area and the rural area. That quickly got into a discussion of what was the rural area paying already, and an investigation of where the LLRW interest money had been going. That's when things really started rolling. We've been on this for 2 years. We couldn't persuade them to look at Schedule 8, and we couldn't persuade them that what their practices in the past had been wrong. Then another thing happened in 2012. The municipality decided that since the Ward 1 money now was, in their view, without a condition, it's actually a point that they're wrong about, but never mind, that they would put the money, put the two $10 million as an asset of the town, of the municipality. And so if you look at the balance sheet and the financial statements of the Municipality of Port Hope for the year ending December 31, 2012, you will see that the $20 million shows as an asset of the municipality. Now, as I say, they may or may not be right about Ward 1's $10 million, but that act of officially taking possession of $10 million that never belonged to them in the first place can be described in some circles in very, very plain language, which I won't use. And it, again, as I say, for the past 2 years, Rick, Bill, and I have been saying, please deal with this, address this, please fix it, to no avail. And it is because so much has happened in other ways to compound this misery. I mean, think of it. In the past 2 years, the municipality has taken over $10 million, literally out of the pockets of the Ward 2 ratepayers. This year, of course, we got the great news that our municipal taxes are going up 37%. So that's a double whammy. Take all our money and then jack up our taxes at the same time. This is the result of a process whose principles were set out to be, let's find a fair and equitable tax allocation between the urban and the rural areas. So that's why this action has become necessary. The town has actually taken possession of our money and publicly let it be known that it's theirs and we have nothing to do with it. So this action is to change. This action is to have the court direct the town to do the right thing. I'm sorry it's come to this, but we are determined to see this put right, and we'll do what's necessary to assure that. This $10 million, which has grown to about 12.5 at this point, belongs to the ratepayers of Ward 2. Whether or not the municipality of Port Hope likes it, that is the fact. And we are here to explain to you that we're darn well going to make this happen. So I sort of run through all your slides, Bill. Would you like to add anything at this point?
Well, I would just add a little bit, not just so that we use the slides, but just to sort of fill in a bit of the information. Some of this events that happened in 2014, you can see some of the public meetings that we had. Subsequent to being on the area rating committee, the committee was summarily disbanded, we thought. And so we formed a group called Port Hopers for Fair Taxes, and that's how we've been forming ourselves. We've had some public meetings, brought some tractors downtown, made some protests, and the day that they made the decision to up our taxes 37%, we circled with about 70 tractors. But staff and council have not listened to us, and you know, the 81% of the rural population that wants to de-amalgamate, or at least sign a petition to investigate that, is some sense of the flavor of the morale. We've also asked them to provide an accounting system for the larger taxation issue, and have not two sets of books, but a set of books that would reflect what's going on in Ward 1 and what's going on in Ward 2, and we're constantly told, oh, that's too complex, it's a one-word system. So we've sort of treated the LLRW fund as a separate issue, but you can see how it's connected, as Ian said. The LLRW inputs are supposed to be used to offset taxes for people in Ward 2. So we feel we haven't been listened to. The discussion around fair and equitable was never really had. There was no justification for this sudden shift of tax burden. There had been a long-standing policy right from amalgamation through to 2012 that the tax burden would not be shifted. Suddenly it was. The community consultation went on. We proposed an option 7. It wasn't really considered. And we don't use the same level of services in Ward 2. These are some of the sort of background information around the larger taxation issue, which LLRW is a subset of. So the trust must be upheld. The beneficiaries of the trust must be formally recognized as Ward 2 ratepayers. And the funds may not be commingled. They can't be, and they have been. Ratepayers can no longer trust the municipality to do the right thing, and that's why we're going to push. And then the court date for the application will be January 22nd. The application to the Superior Court, as Ian said, we want to confirm that $12.5 million is a trust fund, and confirm that the beneficiaries are the residents of Ward 2. So I guess we're ready to take questions.
Absolutely.
Ian, is this technically or legally a lawsuit? It's not. It doesn't. Would it be considered a lawsuit? Like
Yes.
you're suing? It is a lot. So even though it's called an application, and it doesn't have, I haven't read this, it doesn't have damages in it, does it, or does it?
No, it's asking for declarations. It's not an assessment of damages, which a trial will do.
That would follow if.
That would follow. But first we're asking for an accounting. And to expand on that, periodically you may have heard in the past 12 months demands by Port Hope Fair Taxes that there be an accounting of the usages of the low-level interest. And every time it's demanded, there's an excuse. And you know what the latest excuse is? This is hot off the tongue of someone across the street. There's now a lawsuit, so we can't do it.
Will be coming, correct. So just follow that.
Even though we've asked for it in the lawsuit.
Following that train of thought, and then there could and will be a lawsuit, and there's $12 million, I think, you're speaking of here. Does it, one, that would be not quite clear who would get the 12 million or be suing for the 12 million, and the municipality, do you have to know, do they have insurance for that type of thing, or are we looking at a serious problem for the municipality down the road?
This is not an insurance issue. This is a matter of taking the money they have put in their pocket, out of their pocket.
But they have insurance for lawsuits, don't they, like to protect them from lawsuits?
This isn't a lawsuit.
Yeah, but if they
It
have
wouldn't be
insurance,
covered, in other words.
wouldn't be covered.
Okay.
I can't understand how it could.
So the day may come and they have to come up with $12 million.
Well, they
in
took
trust.
it. They took it from us.
Well, they may spend it, but, yeah. Okay.
And you asked, just before that, you asked another question.
I think I asked technically, was it a lawsuit
Yeah.
or an application? And a clarification, timelines. Amalgamation came after this these funds were set up, is that correct?
Yes, sir.
Yes, okay, these funds were set up, and then amalgamation came along.
Yes.
Was there an actual trust agreement entered into by the Hope Township and a trustee?
No, the Hope Township appointed a trustee.
Correct, in accordance with Schedule 8,
Right.
to look after the interests primarily of the Crown, as I understand it.
Look after the interests of the beneficiaries.
Well, it also was there to look after, to make sure the funds were.
Continued to be there,
Continued
so
to
they
be
could be
there
returned if
until
necessary.
the various agreements had met their conditions.
Yeah.
Now, it further stated in Schedule 8 at the end, that when that trigger date occurred, the trustee was absolved of his responsibilities, and therefore, that no longer existed. Is that correct or
Is that
not?
a statement?
Yeah, that's
If
a question.
If so, it's incorrect.
Well, I just was reading the Schedule 8 agreement.
Read the whole sentence.
I did.
It says the trustees' obligations
To
to Canada,
Correct.
not to the beneficiaries.
Right, and that's why I was
So
wondering
the
if
trustee had
actually-
obligations going both ways. Beneficiaries, and
Correct.
oops, I may have to turn the money back to Canada.
Correct. But I just
That
wondered
one's
if a
over.
trust agreement actually existed.
You'll have to ask the municipality. I think I know the answer.
John Floyd. Well, as we're aware, the Port Hope has a severe spending problem. And, you know, as the taxpayers of the municipality, lawsuits are extremely expensive. May I suggest that the simplest solution would be that the Treasury, Town Hall, turn over the facts, the proper accountant, return the funds where they belong. That this would be the solution to the problem.
It certainly would do a huge amount to start to rebuild trust, which has been thoroughly shattered the past few years between those of us in Ward 2 who have been trying to work with the municipality. That would be a huge step forward.
Well, understandably, that is the course that the municipality has to do. There's been a lot of damage. We agree on it. We talk about it. And it needs to be fixed ASAP. Thank you for your answer.
Yes?
Could I just butt in sort of here? I think to give you a little more understanding of how this thing developed and the agreement was drawn up. Ian was part of the committee, of course, that drew up the agreement. And as Ian said, Trot River said that they would take the low-level radioactive waste, all of it, but they wanted something like $90 million or more as a hosting fee, plus they wanted a guarantee that there would be no unemployment at Atomic Energy Canada for 9 years. And of course the government was just, well, what do we do now? And that's when Brent Ainsworth, who was a geologist and was on the Environment Committee, that's when we got together before a meeting and we said, hey, why can't it go where the waste, some of it is right now, welcome. We agreed. We took it up to the committee, and with history that eventually the ad hoc low-level radioactive Hope Township committee was formed. I eventually became chairman of that, and I've been involved with this whole thing ever since. It never seems to go away, except it's going to go away out of Port Hope. I just wanted to point out that when the agreement was in the making, DeVries and councillors invited us, the committee, that had come up with a report, which by the way is being followed almost to the T, and said, hey, we've got this agreement coming up, and we'd like you guys, because you've been involved, we'd like you to know that it's going ahead. And some of them, one of our people said, is there going to be a hosting fee? Probably, but we don't know yet. We don't know how much, and we don't know what's going to be there. And I think I was the one that spoke up and said, well, how can we, if there is one, how can we guarantee that this is going to belong to Hope Township? I would like to suggest, this is me speaking then, that the Hope Township Fund in the agreement should be for a trust for the residents of the geographic area of Hope Township as it exists at the time of the agreement. So right there, it's nailed down. That trust was for the residents of the geographic area of Hope Township. The geographic area of Hope Township is still there, and therefore, I think that puts the nail in the thing and says, hey, it does belong to Hope Township, as it was geographically.
First of all, were you the reeve at the time that this, were you the reeve at the time that this went through?
Yes.
Okay. And what will your group do should the court say there isn't a trust and amalgamation has, I'll say, superseded the trust? I mean, is it dead in the water at that point, or are you wanting to battle on?
I would, my personal view would be, should that be a decision of the Superior Court, we would immediately appeal it to the Court of Appeal.
Are we talking provincial court here?
Yes.
Okay.
Well,
Now, does the federal government not have a say in it as well? Because the funds belong, the
Good.
principal belongs to them.
well, yes and no.
Okay.
Let me try to answer your question. They are the donor.
Yes.
They have decided, here's the money, go away, you can do whatever you want with it. And that was when the do whatever you want terms were worked out. So they are disinterested because the storage site's going ahead. And so they will not have a call on the money to go back to them unless there's a certain ongoing condition, it's a technical condition, with Ward 1. Because there were actually two conditions under which the $10 million returns to Ottawa. One is if there's no storage site licensed in the municipality. And two is if, for whatever reason, all the wastes are removed from the municipality, going somewhere else. In technical fact, that is the present plan. The storage site in Ward 1 was cancelled. It was moved to Ward 2. So technically, when the cleanup is complete in Ward 1, the federal government will become entitled to the return of their $10 million. And that is a reason that should worry the auditors of the municipality, because there's a contingent claim on that money that shouldn't have signed off on the financial statements the way they do.
Well, thank you. First of all, I apologize for being late. My name is Les Andrews. I'm a businessman, not a politician. I've heard with interest the claim that getting the information for Ward 1, Ward 2 split out is too complicated. That's a complete red herring. I sit on the Y board that has about 12 different departments. We get monthly profit and loss statements on each department in quite some detail. And they function with a lot less people in their administration than the town has. So I support you on the fact that you've been stonewalled on getting this information. I've delved into the strategic financial plan, the 2013 annual financial statements. I've asked for the 2014 annual interim statements, and I've been told that there is no interim statement. They only occur when the council approves the final draft, which would mean we would operate the whole year without the financial knowledge, which I find unbelievable if true. Thank you.
Just to add to your knowledge possibly, I have here some comments by a very experienced chartered accountant who's gone over the financial statements of the municipality, and his comments include in 4 of the past years, in fact 7 of the past 10, this municipality has actually budgeted for a deficit. 4 of the past 5 years, the municipality has spent more than it raised in revenue, and to pay for the shortfall, it has increased borrowing in 7 of the past 10 years. There are a few other comments, but before amalgamation, the debt of the municipality was $2 million. Hope Township's was 0. The debt at the end of 2012 was just a whisker shy of $40 million.
What period of
48
time?
million as of 2/13. That's long-term debt.
Is this lawsuit essentially a class action suit on behalf of the
Yes.
ratepayers? I see.
A class action suit has a certain meaning, but we are doing this on the behalf of others. Yes.
And somebody brought up the subject of costs. What kind of costs do you anticipate might be involved? And what length of trial do you think may be involved?
The trial will take 1 day estimate, possibly a day and a half. And yes, we are raising money from Ward 2 ratepayers to finance this. There's, as you can tell, there's a law firm in Toronto doing it. I am involved in the background. I've prepared a lot of the briefs to try to keep the costs down. So my involvement is pro bono, but the Toronto lawyers have to be paid.
Yeah.
The court has agreed to hear the case.
January the 22nd, the date is fixed.
Okay. The $12 million, does that include the basic, does that include interest as well?
It's $10 million of principal, and we're estimating based on a couple of statements that we have seen, but it would appear that there's $2.5 million, maybe more, that is there. And what has happened since 2012 is that the council has authorized the use of $150,000 of that money to reduce the Ward 2 taxes. All the rest of the growth in that fund would appear to have to still be there, because there's been no resolution authorizing the room taking any of it and putting it in. So it should all be there, and if it has been moved, we want to come back.
The municipality has never given you an itemized account of how what the money stands for, how much is left over the last 12, 14 years.
2 years ago, we got 4 different versions of such an accounting. Dean got a version in 2010 from the then CAO, which is similar, and probably is the one that Mark Cranch used, which is in the materials. So that there are various iterations floating around, and that is why the staff were instructed some months ago to bring forward the accounting.
Ian, when you talked about the accountant view of the 10-year period, ending when, 10 years ending when, in the document that you were referring to as council having budgeted for deficits for a certain period of time and then over borrowing.
That would be 2002, 2012. The 2012 statements would be the most recent.
And you referred to the 20 million, okay,
Yeah.
being on the balance sheet. And 10 of it, of course, technically not being the municipality's money. That's malpractice from an accounting standpoint, would that not be? If you can point out that the 10 million is not their money and they've actually stated it on the balance sheet?
We don't know if the accountants have ever been told anything different than follow Schedule 7. We don't know. We'll find that out. We're behind you and stuff.
Yeah, Terry Hickey, my question is, let's say the municipality acquiesces to hand over that money, or you get that decision in court. What would be your plan then to manage that money? Who would manage that money physically?
CIBC, if they wished.
So it would remain as it is, just with the condition that it be used for its original intent.
If I were to be picky for a minute, I would say that the trustee, the CIBC, who probably haven't really been told a lot about their trustees' duties, they need to act like a real trustee.
But are they in fact currently a trustee, or simply the institution which invests the money on behalf of the municipality? Is there a trustee agreement in place?
We don't know that.
Okay.
We don't know what, but according to the grant of the trust, they are the trustee. According to NR Canada, they are the trustee. Because there was an amendment made to the agreement in 2003 that allowed the town to use the CIBC instead of the Royal Bank.
Thank you.
Okay. Bob Karen, Ward 1. I haven't gone to council meetings in a long time. But when I did go, I seem to remember a conversation. I'm wondering if it ever showed up in your deliberations or at your committee. At one point, way back, probably 2000, right after the fund was set up, or within a couple of years, there were two separate funds. And I remember an instance where Schedule 7 and Schedule 8 debates come up in council, so it should be in the minutes. The debate at that time, if I remember correctly, was that your fund had more money in it than Ward 1's. So the debate was, if Ward 2 can invest their money better, maybe we should change the fund for Ward 1 to go to the same trustee. You know.
Yep, your recollection is very close to mine.
If I remember any of that,
Yep.
like it seems to me there were two funds, so this lawsuit has to go in, you know, to the extent that, I guess it settles Schedule 7, Schedule 8. The other part of that debate was that, if I remember correctly, the residents of Ward 1 at that point said, hey, we kind of like what Ward 2 is doing with their money. Our taxes are going up. That's what the money is basically for. So maybe it should be used in Ward 1 to the same schedule as it's being used in Ward 2. Do you remember any of that? Or
Yes, I do.
Just a thought?
I recall that the Ward 1 money was being better invested than the Ward 2 money. I could be wrong, but yeah, there was an imbalance. And also, yes, I remember Ward 1 saying, why don't we get this money ourselves? But there's always been a strong push by councils to not distribute the money, and there were resolutions of council in 2003, 2004, saying that wherever possible, this money should be put into the building and equipment reserve to finance all the buildings in Ward 2.
Which you haven't got.
Ian, I recall being in council when there was discussion about the revenue from the Hope Township $10 million was less than that of the municipal dollars, and Fran Aird was still here. This was before she retired, so it'd be 03. And that may have been the motivator for why they changed the, or thought they were improving things, who knows? Who knows, but certainly.
There's no question that it was well-intentioned. It was a well-intentioned move to have the CIBC administer the $10 million because they were doing a better job than whatever else was done. And I think they've done an excellent job throughout. They just haven't done the things that a trustee ought to be doing. There ought to be a report to the beneficiaries once a year. This is your money, this is what's happened, this is what we've done with it, these are our fees.
And of course, Fran, having come from Hope Township, you know, I thought she was wonderful, because I had just arrived here at Port Hope. And then things started to change with changes in staffing and maybe practices along with it.
Well, she was my CAO, I can't speak too highly about her. No, seriously, thank God I had her as a CAO. Made my life so easy.
Could I just put in a little word here? Smith was the mayor at the time that the agreement was drawn up, and he saw fit to take the wording that we had put into number 8, and he said that the trust income will be for the purposes or for the credit of the residents of the geographic area of Port Hope as of that date. But he did not state how that money was to be used in Ward 1. That's a big difference right there. But that's the only place that the two do differ. But there's one other thing, that the monies, the income from the Hope Township Fund also has this statement in it that the income from 1 year will be distributed to relieve the low level of tax or whatever the heck it is of the residents, taxpayers in Ward 2. But it will be limited to a value of 8% of the amount that's in the trust. And Ian pointed out to me the reason that that was put in there was that at that time interest rates were fairly high, and this was to balance out, and hopefully the income would be over the 8% and some of it would go back into the trust again and to build the trust up. So that's another thing that does enter in the background of this whole thing.
Karen, you had 2 or 3 points.
Yes.
Caroline Fountain, Rural Redesign. I'm curious, there's a lot of conversation in this room today about the financial implications, but I'm also curious about the human implications. And what I mean by that is it sounds, listening to this, as if there has been an enormous amount of incompetence, neglect, a lack of transparency. I think Les Andrews' comments were very interesting about, we can't do that kind of accounting because it's much too complicated. Excuse me, but that's baloney. So let's just assume for a minute that on January 22nd, the court says, you are right, the trust is valid and needs to be returned to the residents of Hope Township. Are there any consequences for the people who have behaved badly, acted inappropriately, or conducted themselves in an immoral fashion?
My answer to that is that we have tried very hard to bring this issue forward during the election period, because we want everybody in the municipality to learn as much as possible about this and make their own decisions as to how we got to this situation before they go to the ballot box.
That was a very vague answer. Sorry, but it was.
Yes, there are consequences.
Thank you.
If we're talking about firing people, I'm not going to discuss it.
How soon,
Here.
how soon do you expect to get an answer when, after January 22nd?
Oh, that's a good question. And I'm sorry, I am a lawyer, but I can't defend some of the practices that lawyers and retired lawyers, every judge is a retired lawyer. Some of them are inordinately slow. However, that said, we're dealing with a very simplistic issue here. We're dealing with very clear legal precedent. And we're dealing with a pretty darn clear set of facts. There's not a lot of confusing verbiage in this whole thing. Really, it sort of boils down to, you got two pages, Schedule 7 and Schedule 8. They're each a page long, or page and a half. That's the case. That's the essence of it. What do these 2 pages mean?
But do you think this could go on, first of all, the decision could go on for months, awaiting the decision, go on for months, and then in terms of, if it does go to court, like, are we looking at years of legal wrangling?
No. No, this application process is a forced march by both parties to the courtroom. And that court date is set in stone. It's January the 22nd, 2015. Mark your calendar, save the date. There's no admission. It's over at Coburg on William Street. Between now and then, we've put our best foot forward. The town must respond. They have to decide what they're going to say in response to what we have put on the table. If they put forward anything worth asking serious questions about, there's a process called cross-examination, where the individuals signing the affidavits can be cross-examined. Why did you say this? You know, what does this document mean? All of that's got to be completed, and a pile of paper 3 times that high presented to the judge a few days before January the 22nd. He reads it all, honest he does, and then the lawyers for each side get up and fix their case. There are no witnesses heard that day. That's one of the keys to keeping this process short.
Is that document that the town responds with, is that public?
Oh yes, the whole thing.
So how will we know when they respond? You'll get the response.
We'll get the response,
So
and we'll
we'll
make
hear.
sure that everybody
Terrific.
knows
Okay.
about it.
This could be highly speculative, but it sounds like from your point of view, it's an open and shut case. What do you think the defense will be on behalf of the town?
We needed the money.
I think that's the best they can do.
I'm a lawyer.
I know.
I set this thing up.
Mhm.
So, okay, I'm one-sided in my opinion. I've looked at their legal opinion. Won't say anymore. Our lawyers have looked at the situation. They've looked at the papers.
When you say you've looked at their legal opinion, what do you mean?
Well, the town got a legal opinion,
Oh, I
a
see.
thing they called a legal opinion.
Okay, on the subject.
Yeah.
All right.
And we can't find any flaws in our logic. We really can't.
Okay.
I mean, because when you start out to set up a trust, and that's why Dean Ross is here, because he helped set up this trust. And so what was the intention of the parties at that time? We're here to tell that story. The paper is here to demonstrate the story. That's the story.
Louise Fletcher, if the town solicitor at the time, is that the same as who's representing the town now?
Year 2000, I think it was Doug Mann was the town solicitor at that time.
How many, offhand, do you know how many solicitors have represented the town in the interim?
I believe they switched to a firm in Belleville some years ago, and as of this afternoon, they're still with
They're
them.
the current.
And is there not a implication here to the fiduciary, oh, I'm sorry.
No, you go ahead.
Fiduciary responsibility of the CIBC? You said, you know, the CIBC would.
There is, but I don't think that they've been made aware of it really.
Should they be aware of it?
Yes, they should be made aware of what's going on, and the accountant should be made aware.
And if they were aware, they might well have gotten involved. In other words, I'm looking for the thought that the CIBC have not followed their fiduciary responsibility of overseeing $10 million.
You would think that they would have made better inquiry than
Yes.
perhaps have.
In looking over the town's legal opinion, was there any part of it, without going into the case details, would state that the amalgamation process superseded anything that occurred in Ward 1 and Ward 2? Or,
Oh, he threw that in too.
that's in there, it's up to the judge.
What Ian just said a minute ago, and he's a lawyer, and I think he's in this because his heart's in it. I'm an engineer, was, and retired, and I started this whole ball rolling, and I don't want to see him getting any bumps and bothering anybody. I'd like to see everything going the way it's going. The project is going fine, I'm keeping an eye on it, thanks to some of the people I know that are in it. And my object was at the beginning to see this whole thing through, that there was money and people were going to receive something because of being host, then I want to see that they get the full benefit of that, and it doesn't go further away with somebody else. I said my say.
I'm wondering